My name is Sean Fettermeyer. This is Intellectual Property Rights and Globalization. Globalism and the ubiquitous spread of multinational biotech and agricultural companies are having a deleterious effect on indigenous and farming communities worldwide. At stake are not only the livelihoods of the individuals and communities in question, but also billions of dollars in profits from the marketing of products created through intellectual property rights. First, we need to understand what intellectual property means. Several governmental and non-governmental organizations have attempted to define what intellectual property means in a legal sense, but there's a problem. What the Western world constitutes as individual property doesn't hold the same meaning for indigenous groups and can even differ from country to country. One of the main issues here is attempting to apply a Western view of what property is to non-Western cultures. This ethnocentric viewpoint only validates what an individual or company creates or discovers and makes it difficult to apply the concept of ownership to a group of indigenous people who may not see it the same way. In many indigenous cultures, there is no concept of owning an idea or a discovery like we have in the West. So when a company comes in and discovers something that a tribe has known about for generations, it is difficult for the tribe in question to protect their intellectual property rights under international law. Currently, international law only recognizes a few different types of intellectual properties, and none of them specifically apply to indigenous or traditional knowledge. Patents, copyrights, trademarks, industrial designs, and trade secrets are currently the only legal tools available to protect knowledge or resources that a corporation may want to exploit. Due to the utter lack of protections available to indigenous cultures under international law, the UN has recently begun to take steps to protect the rights of these people by drafting the Declaration of the Rights of Indigenous Peoples. This document is a good start, but it is not legally binding to member states and doesn't specifically afford any protections. So, how did we get here? Like so many other international socioeconomic issues we currently face, our problems started during the Reagan administration. The combination of market forces, a Supreme Court decision, and administrative economic policies created a perfect storm where governments, corporations, and academia could all come together under the umbrella of profit. At the time, biotech was still in its infancy and had yet to show its capabilities to the world. This changed when, in the case of Diamond versus Chakrabarty, the Supreme Court decided that a life form could be patented so long as it came about through the ingenuity of people. The vagueness of this decision has led to companies patenting medicines or agricultural products that, by all rights, weren't really theirs. Not long after this landmark decision, the Reagan administration promoted the development of partnerships between universities and corporate investors. Combined with the continuing trend of lessening federal funds, universities were now essentially becoming profit-driven by way of investment and began seeking out patents of their own. The other major effect this had was the conglomeration of corporations. Large chemical companies began buying out smaller biotech firms and merging with food, pharmaceutical, agricultural, and energy companies to create the too-big-to-fail multinational model that we see today. With modern economies so dependent on these types of companies, it gave them vast amounts of sway in international markets and with state-level legislators. In many instances, legislators have been persuaded to relax the laws governing these industries or to side with corporations in intellectual property disputes, but the tables are starting to turn. More and more governments, non-governmental agencies, and intergovernmental bodies like the UN are beginning to understand that the resource-rich developing world needs to be protected from exploitation and that these people have a right to benefit from and profit from their own heritage and cultural knowledge base. Not only are there billions of dollars in royalties and profits at stake, there is also genetic diversity to think of. While GMO crops are being sold as being better producing, hardier, better versions of the crop in question, when they start to fail, there is nothing to fall back on, as the model they are sold under almost guarantees a monopoly. By using terminator genes, which make seeds unusable, and charging royalties for any seed that can be kept and used, these large multinationals push out any competing heirloom varieties quickly. For those that refuse to use their product, it is only a matter of time before pollen contamination makes it so that the company can sue any farmer whose field has been contaminated for using their product without paying. There have been several instances of cases like this in the United States and Canada in the past 2 decades. Even on the international scale, companies like Monsanto have tried these tactics, but in some countries, like India, they are fighting a losing battle. India has 2 major instances of intellectual property abuse that cover both sides of this issue. With BT cotton, Monsanto came in, created a monopoly, and it is now failing. In the instance of the neem tree, several multinational companies have started patenting and selling something that has been known about throughout India for generations. BT cotton is a cotton variety that has had a gene spliced into it that makes it create its own pesticide. These plants have also been made to withstand high levels of herbicides and pesticides. After initially dominating the Indian market, crop failures, the increasing need for more and more fertilizer, and the destruction of soil health has made Indian farmers start to fight back by planting different crops altogether. The neem tree is known in India for having many uses, from medicine to agriculture and even as an insecticide. It was this last one that caught the eyes of corporations, as insecticides are a $2 billion a year market. Remember that problem with defining intellectual property? Well, in India, it is not legal to patent things for medicinal or agricultural use, so it has sparked much debate on both local and international levels. By losing the genetic diversity once afforded by heirloom crops, and seemingly losing the rights to something that has been known about for centuries, it seems like India is losing the battle, but it's just beginning. Between protests hundreds of thousands of people strong, and international lawsuits being waged by activists on behalf of their countrymen, the people of India are setting an example for the rest of the world to follow. In summary, the international war for intellectual property rights has just begun. Right now, the multinationals have the advantage on the rest of the world. They are entrenched in a system that was created by them to benefit only themselves and have vast resources. But the tide is turning against them, and they are fighting a losing battle against superior numbers that hold the moral high ground.